G'day everyone, and welcome to the fourth and final video for week 3 of our legal ethics course. The theme for this week has been admission. We've looked at why we have an admission process, we've looked at the process itself, we've looked at some of the things that might get in the way of an applicant's admission, and then finally we talked about the process for early consideration of suitability, just in case one of those suitability matters has got you worried. So now, you've completed your LLB, you've done your practical legal training, you've applied for admission, you've been to the ceremony, you've given your mover a bottle of something nice, mum was crying, dad was making stupid jokes about having a lawyer in the family. Surely now, after all this, you're ready for practice. Almost. The final thing that you're going to need in order to sail off into your career is a practicing certificate, issued either by the Law Society if you're a solicitor or by the Bar Association if you're a barrister. In this video, we're only going to look at the solicitor side of things because the process of becoming a barrister goes a bit beyond this course. Why do we have practicing certificates? Well, the first thing is admission is a one-time thing. Once you're admitted as a lawyer, then you're admitted forever, unless for some reason you become struck off. Your name will remain on the roll of lawyers permanently. And yet at the same time, the need for the law to regulate lawyers doesn't end with admission. Driver's licenses are a good analogy here. Most people only ever do one driver's test. Once you've passed your driver's test, then you're licensed to drive. I did my driver's license test in 1991. More than 30 years later, I've never had to go back and prove to anyone that I could still drive. That license test is kind of like admission. Once it's done, it's done. However, once you get that driver's license, you do have to renew the license regularly. You have to pay fees. You have to keep the address up to date. You have to get your eyes tested when you renew. The license itself is the means by which the law regulates you as a driver. Well, your practicing certificate is kind of like your driver's license. You need to update your practicing certificate every year. You need to tell the Law Society every year which firm you're working for. And as we'll see in future weeks, one way that lawyers can be disciplined is by removing their practicing certificates or putting conditions on that certificate. Now, there's a range of different types of practicing certificate, and I want to go through them one by one. First and foremost, government lawyers are not actually required to have practicing certificates so long as they're only doing government work. This means that government solicitors, for instance, can't represent someone in court in a matter. A long time ago, when I was a legal officer in the Royal Australian Air Force, I was admitted, but I didn't have a practicing certificate. Didn't need one. Next, there's a thing called a volunteer practicing certificate. These are issued to lawyers who only want to practice in volunteer pro bono services such as Law Right or the community legal centres or the Women's Legal Service and so on. Volunteer practicing certificates are issued free of charge. Third, there's a whole category of practicing certificates called employee certificates. There are 3 types. The first is a restricted practicing certificate. These are issued to lawyers who have only just commenced practicing. You'll be on a restricted practicing certificate for most likely your first 2 years as a solicitor. If you have a restricted practicing certificate, then you're only allowed to engage in supervised practice. So this means, in all likelihood, that you will not be allowed to communicate with the court or your opponent, or often even with the client, unless someone more senior and more experienced than you is supervising your work, which means checking every substantive email or letter before it goes out. All of this recognises that even after your LLB and your practical legal training, you're only going to have the most vague idea about how legal practice actually works. You'll be reliant on older, wiser heads to show you the ropes. Second, there's a different type of restricted practicing certificate that's only issued to in-house counsel, and only allows them to act as in-house counsel. In-house counsel are lawyers who work in a particular organisation, usually a large corporation. Sometimes those corporations are so large that it makes more economic sense for them to just hire a lawyer full-time, rather than engaging a legal firm every time they need something done. The thing is, anyone practicing as in-house counsel is likely to be practicing a very narrow type of law, usually involving internal advice and only very occasionally involving dispute work. So the restricted in-house counsel employee practicing certificate reflects this. Next, we have the unrestricted employee certificate. This is the one that most solicitors have. This certificate enables a solicitor to practice without any restrictions, provided that they remain an employee and so they don't hold themselves out either as a sole practitioner or as the principal of a firm, that is, a partner or director. Finally then, we get to principal practicing certificates. For most of you, this is some years down the track, unless you have immediate ambitions of starting your own firm. Principals practicing certificates are granted to those who become partners or directors of a firm, or if they become sole practitioners. To get a principals practicing certificate, you have to complete an additional course. It's only about 5 days long, focused on ethics and the operation of trust accounts. So the very stuff that we're talking about in this course. And you have to show the Law Society that you actually are practicing as a principal of a firm. So having a principals practicing certificate is not just a flex. Practitioners who have principals practicing certificates or unrestricted employee practicing certificates can then supervise those who have restricted practicing certificates. So you can see straight away the practicing certificate process allows the Law Society to regulate lawyers according to the type of work they do, whether they're a newbie or a volunteer or a government solicitor or in-house counsel or an experienced practitioner or a principal. In addition, the practicing certificates become the point at which the profession can regulate other matters. For instance, when renewing their practicing certificate, solicitors are required to make the prescribed contribution to the Legal Practitioners Fidelity Guarantee Fund. That's a fund that exists to compensate anyone who is harmed, usually financially, by dishonest conduct by a legal practitioner. Fortunately, this is quite rare. Solicitors do have insurance. Indeed, you can't get a practicing certificate without it, but insurance normally only covers negligence. Insurance normally won't come to the party if a solicitor is deliberately dishonest. And so the Fidelity Fund exists to give clients security, knowing that if they give money to a solicitor, for instance by placing money into the solicitor's trust account, even if it turns out the solicitor is dodgy, the client will be protected. It's all part of ensuring that people understand that despite all the lawyer jokes, they actually can absolutely trust solicitors, including trusting them with large amounts of money. Finally, the annual issue of practicing certificates allows the Law Society to regulate each solicitor's obligation to undertake 10 units of continuing professional development each year. A unit of professional development is usually equivalent to an hour of work or 1,000 words of a legal journal article. Journal articles are therefore not super attractive because it takes much longer than an hour to do a journal article. Each year, each solicitor has to include in their 10 units at least 1 unit of practical legal ethics, at least 1 unit of practice management and business skills, and at least 1 unit of professional skills, that is, learning about the law. There are a range of organisations out there that offer free CPD units, and the Law Society itself has a whole range of things online for members, including videos which you can watch for CPD points. In addition, many firms hold internal CPD events where one member of the firm provides training to others. Despite this, there's always a mad rush in March each year by people who haven't kept up with their CPD and so they're in a rush to get it completed by the March 31 deadline. What this also tells you is that this course is not going to be the last you'll hear of legal ethics. If you go into practice, then every single year that you remain in the profession, you'll be required to undertake CPD on legal ethics. Okay, well that brings us to the end of week 3. This week has been all about admission. We've looked at the whole purpose of admission and how it works. We've looked at how you go about applying for admission. And we've then linked admission to ethics by looking at a bunch of the ethical pitfalls that can get you refused admission in the first place. Finally, following admission, we've talked about the need to hold a practising certificate, and along with that, the need to complete compulsory professional development. Next week, it's probably the most important week of the course in one way. Not so much in terms of passing the subject, but more in terms of becoming the right sort of lawyer. You see, the one thing that must be first and foremost in the mind of every lawyer is that our highest duty is always to the court. Our duty to the court is higher than our duty to the client. It's higher than our duty to our own self-interest. Duty to the court comes first. And if you can't accept that, then I don't want you to join our profession. This duty is who we are. It's what we are. On that serious note, I'll see you next week.